So this week we are talking again about sentencing, but we're going to get more into the disparities of sentencing as well as the appeal process. So the introduction, basically talking about how the sentencing scheme is not simple. It's very in-depth, and it takes a lot depending on the jurisdiction and the individuals involved to complete sentencing. Because jurisdictions are all different and some have enacted tougher laws, there's going to be a lot of difference in sentencing options. Many jurisdictions, especially for serious and repeat offenders, judges do not have any discretion to decide between prison and probation. They must be sent to prison. Well, what does this do? Well, it definitely overcrowds our prisons, right? And we'll get into that in a little bit. Less serious crimes or cases have indeterminate sentencing, and judges have a fairly wide discretion to tailor the sentencing. Means they could give probation, they could give community service, they could make it a felony or misdemeanor, so there's a lot of discretion on the less serious crimes. Different judicial sentencing options could obviously be incarceration, probation, and then the death penalty would be the extent in certain jurisdictions. Jail or prison sentence is an option for most criminal felony cases. The U.S. has one of the highest incarceration rates. We have 5% of the world's population, but 25% of the world's prison population. So out of most countries in the world, we are significantly larger in terms of who we incarcerate. In your book, if you look at tables 10-1, it shows sentences of convicted defendants in 2009. And then table 2 shows the length of their term. So you can kind of see how it varies from the US to other countries. Our primary alternative for incarceration is probation. Straight probation sentence does not entail confinement or jail. And in 2009, there are 4.3 million people on probation in the US. It shows 17% of the people, the individuals on probation, were incarcerated due to a revocation of the probation or some sort of default in their probation, that they didn't follow whatever they said they would follow, and therefore they were reincarcerated. Table 10.3 shows the statistics of convicted defendants. And regardless of conditions attached to a sentence of probation, all probationers are required to obey the law and maintain contact through face-to-face visits with their probation officer. I know quite a few of you in here are interested in probation and going into probation, so this chapter is probably going to be fairly interesting for you. You must have regular meetings. Offenders must obey all laws. There could be drug testing or substance abuse testing, and most likely they need to enroll in educational programs designed to shock or scare the convicted offenders, particularly those who never served time in jail. Our idea as a system is to hopefully keep them out of jail, and depending on how long their probation is, to make sure that they're not committing any other crimes as well. And then depending on their incarceration times, they could be taken out of jail and resentenced to probation and given a longer probation term. The death penalty, obviously, is on the other side of probation. It's reserved for only those who have committed capital crimes, primarily first-degree murder. In 2013, 60% of all U.S. citizens support the use of suitable punishment for a convicted murderer, whereas 35% opposed. It is a very hot-button topic. We do not have the death penalty currently in California. That has been put on a stay, so nobody on death row, their sentences have been commuted to life without the possibility of parole. The death penalty is used as the maximum punishment. The minimum age for executing is 18. And aggregated circumstances, murder for hire of a police officer, torture, commission of another crime, those are what's going to get the death penalty. And in death penalty cases, it's a bifurcated trial. So you have to prove guilt or innocence, and then they would also have to deliberate on potentially getting the death penalty, and there is an automatic appeal for those individuals. A sentence hearing is for anyone convicted of a felony crime, and that's where either the judge or the jury, depending on if it's a death penalty or not, are going to look at the extenuating circumstances. So what happened? What have they done before? So on and so forth. Aggravating circumstances are going to be increase the punishment. So, could be a weapon, gang enhancement, bodily injury, death. Whereas mitigating is on the other side. It's going to lessen the severity. So maybe they're cooperating or they're a younger individual. Those are going to help mitigate or limit the sentencing. And then a PSI is done, usually by a probation officer, to look at the pros and cons. What are the functions? Well, again, give them enough information and evidence to make an educated determination as to the punishment and help furnish the parole boards with the background data. A defendant sentencing memorandum is a document prepared by the offender that describes the crime, why they committed it, and then, obviously how they feel about it. On the other side, victim impact statements are given by the victim or the victim's family to help let the judge or the jury know exactly how they feel about it. And sentencing disparities. So in 2008, 93% of prisoners in federal and state prison were males. Males had an incarceration rate 14 times larger than females, and the male imprisonment rate was 943 per 100,000 versus 67 per 100,000 for females. Usually disparities are based on extra legal factors such as race, gender, and age. They're often unwarranted because the law does not allow judges to consider that demographic under the law. Incarceration rates by genders and ethnicities are in table 10.4 in your book. You can check those out. Obviously, race is a big factor in what we look at in terms of disparities. Harshest sentences usually go to Black and Hispanic males. Some research shows that there may be a case that judges give a little bit more to females. So as a society, we don't think of females as committing crimes. Society's supposed to protect females. So there is potentially a bias there when females are being sentenced. And then socioeconomic, traditionally the lower socioeconomic areas seem to have harsher punishments. And lastly, we're looking at appeals. So if a defendant's convicted, they always have the right to appeal. This makes sure that the trial court did not err in their determinations and that they were fair and equitable. All death sentences are automatically appealed. And then an individual may decide to appeal based on the facts of the case and what happened. If there was a law that was incorrectly used, that would be an appealable determination. Appellants are the people who initiate the appeal, and appellees are those who won in the trial court and make arguments against reversing the decision. We always use what's called stare decisis, or legal precedent. So this binds lower courts to issue a ruling consistent with those higher courts, where the same type of cases and facts are at issue. The principle of leaving undisturbed a settled point of law or particular precedent. So if in a jurisdiction, there's already been a precedent set for, say, murder, the court is bound to follow that legal standard of what's happened in a particular case, especially if it was determined by the California Supreme Court or appellate courts. The right of habeas corpus petitions means that you are appealing to the higher courts, and it challenges the facts of confinement, the length, and then the nature of the confinement. A writ of certiorari allows the higher courts to direct a determination to the lower courts for review, especially death penalty cases. If they can make a compelling argument, then they are able to be heard by the U.S. Supreme Court. The ruler of four applies where at least four of the major justices agree to hear the case. Even if the U.S. Supreme Court consents to hear a case, the sheer volume of scheduled cases are going to make it difficult to be heard because there's a limited quality of time. And then you're going to get a notice of appeal, and you'll have your attorney be able to make oral arguments in front of the appellate court. They can do one of three things. They can reverse the case, they can remand it back down to the lower courts, or they can affirm the decision. So they could say, actually, we agree with it. And even if in the appellate courts there are either 3 or 5 judges, one may have a dissenting opinion. If it's the minority dissenting opinion, then they would in fact go with the majority opinion. Appeals of any kind, especially death penalty, take a long time. On average, it takes 10 to 11 years for an inmate to be executed. As we know in California, previous to the stay of executions, it was a lot longer than that. It was, 15 to 20 years. And then lastly, wrongful convictions, and you'll get into these in your assignments, so I'm not going to spend too much time. But obviously, race, gender, socioeconomic status play a huge part in wrongful convictions, and evidence in most serious criminal cases should be preserved for years so that there's the potential to go back and relook at it, especially DNA evidence.